So before we get into it today, I just want to remind everybody to like, share, and subscribe these videos. It really helps with the algorithms. We're trying to get this message out to as many people as we can, and it really helps. So again, take a minute, pause the video, like, share, and subscribe to these videos so that this good information can get out to as many people as possible. So we have the wonderful opportunity today to be joined by Chuck Michel. He is the volunteer president of CRPA. He is also senior partner at Michel and Associates. He has influenced a lot of great and positive change within the Second Amendment advocacy through litigation over the years. And I think more importantly, he would tell you that first, he is an activist. So Chuck, thank you very much for coming on.
My pleasure. I'm glad we can help get the word out to folks about what's going to be the most important Second Amendment ruling from the United States Supreme Court in over a decade.
Yeah, and that ultimately is what I wanted to go over with you today, and I thought it would actually be a good idea to get an all-encompassing kind of view of what has led up to this case, and then obviously what our expectations of the decision will ultimately be. So if we can just backtrack, going back, the questions that we have now and what we're seeing in the courts is actually kind of a new phenomenon, right? As far as landmark cases are concerned, the first one that we really saw was in 2008. Prior to that, everything that we saw from the gun control, advocates was through the legislature. We saw some big acts come in 1938. We saw another one come in 1968. I'm curious, as somebody who was working in this field on the judicial side, what was really the perspective of the Second Amendment according to the law prior to 2008?
Well, it's funny that you say that. Back in 1934 with the the National Firearms Act, the Solicitor General of the United States actually said that the Second Amendment was a fundamental individual right. There was much debate about whether or not the Second Amendment protected a fundamental individual right or the right of the states to form and arm a militia, sort of a collective right of the people in every state to have a militia. That argument was litigated multiple times. And there were a couple of Supreme Court opinions that came down, which didn't really address it directly, although both sides of the issue tried to argue that they did, or did argue that they did. And I think that the Supreme Court acknowledged that the Second Amendment was an individual right a long time ago. But finally, in 2008, the Supreme Court addressed that issue directly, and ruled that the Second Amendment does protect a fundamental individual right to keep and bear arms. Then in 2010, the Supreme Court ruled again and said that both state and local governments are also restricted by the Second Amendment from infringing on that right to keep and bear arms. So those were great opinions, but they left a lot of questions unanswered. And since 2008, CRPA and other groups have been pushing litigation in various states and over various issues to try and get that question, another Second Amendment case, back to the Supreme Court to sort of flesh out what the parameters of those protections really are and to determine what the standard of review should be when you're evaluating the constitutionality of a gun control law.
Right. So, yeah, I mean, going back to Heller, that was in 2008, and that's where we finally hit that landmark case of, establishing an individual's rights. You worked on that case, right? You participated in that.
CRPA was involved in that case as an amicus, and we worked on that case. That we weren't representing the parties in that case, which was Dick Heller, who has since been involved in several more lawsuits with Stephen Hallbrook, a good friend of mine, and some others. But the CRPA and a number of other groups all participated by filing friend of the court briefs and supporting the efforts to get that case decided ultimately. Even though initially there's a lot of backstory on Heller, it wasn't necessarily a good idea to bring that case to begin with, because the way the Supreme Court was stacked when that case was filed, we probably would have lost. But thankfully, we had a couple retirements and a couple reappointments from Bush, who changed the composition of the Supreme Court so that we ultimately won that case in 2008. Since then, there's been a flood of litigation. CRPA has been involved in most of it, especially in California, all of it in just about in California, trying to figure out what exactly the Heller ruling meant and what it stopped governments from doing. Unfortunately, a lot of the courts have the anti-gun owner courts, who are hostile to the Second Amendment, have sort of bent over intellectually backwards to try and uphold gun control laws, even if they wouldn't meet the scrutiny that should be applied to those laws to determine whether or not they're constitutional. So what we hope will happen now in the Supreme Court is they will apply not just evaluate the constitutionality of the New York State licensing scheme to carry a firearm in public, which is basically similar to California in that you have to demonstrate a special need. You can't just say, I would like to carry a gun for self-defense and get a license to carry it that way. You have to show almost to the level of having to show some kind of threat, and the person that's threatening you, you have to articulate some kind of a specific threat before you can demonstrate a special need and get that license to carry in public. It's similar in California, where you have this good cause standard, and in some jurisdictions they interpret good cause very narrowly. In other jurisdictions, thanks in large part to our initial win in the Peruta case in the Ninth Circuit, where the Peruta courts, the three-judge panel in the Ninth Circuit, struck down California's good cause requirement, saying you can't require a special need to get a permit or a license. You have to let folks get a license for self-defense. And unfortunately, as has become the Ninth Circuit's sort of standard operating procedure, when we win something at the three-judge panel, they take it up to an 11-judge panel to try and overturn the three-judge panel, and they've been successful in Peruta and Duncan and several other cases that the CRPA was involved in to take those wins away from us. But interestingly enough, with the concealed carry laws, a very conservative line of thinking went into that initial Peruta decision where we won, and the California good cause standard was struck down. And the reasoning of that language was then taken by CRPA primarily to a number of sheriffs and police chiefs across the state, who then reevaluated what they had been requiring to establish good cause based on the persuasive arguments made in that Peruta decision. And that's why we have a whole lot more jurisdictions in California that are issuing permits these days than there used to be. For example, Orange County now has 20,000 permits where they used to have almost none. Even LA County recently has sort of seen the light and has issued, they've got almost 5,000 permits out there, licenses to carry, where before they had a couple of hundred, and it was mostly the judges and prosecutors. So in a lot of the rural areas, you can get a CCW, a license to carry a concealed weapon in those jurisdictions, because the people, the issuing authorities, listened to the reasoning of the Peruta case and saw that it made sense. And so they changed their minds and lowered the standard.
So going back to Heller, so that you mentioned that the decision came down and it was interpreted differently by people, and that's kind of the general sense of things, right? And
Heller didn't resolve all the questions. It left a lot of questions unanswered, unfortunately, and that's normal. The Supreme Court can't deal with every question in one case, but they haven't been willing, and it's primarily because we think Justice Kennedy, who was on the Supreme Court before, didn't want to take this up. The Supreme Court hasn't been willing to take another Second Amendment case until about a year ago, when they took the New York case. And so now we're going to get some explanation of what is and what is not constitutional through the Supreme Court's ruling. And we're very, very hopeful. In fact, we expect, and even the gun ban lobby expects, that we're going to win this case. New York's restrictive public carry scheme is going to be struck down. And more importantly, the court's going to decide what the appropriate standard of review is to apply when a court is evaluating the constitutionality of a gun control law. It used to be that there were sort of tiered levels of scrutiny: rational basis, intermediate scrutiny, strict scrutiny, and depending on how much scrutiny was applied, a gun law had more or less chance of being declared unconstitutional. This is borrowed from First Amendment jurisprudence, where you have sort of political speech or speech that's critical of government is subject to strict scrutiny. You can't ban that kind of political speech, as opposed to commercial speech for like advertising a product. The government can regulate that more because it's not as core speech. The courts have drawn from the First Amendment the First Amendment standard of reviews and sort of tried to apply it to Second Amendment. And the problem with that is that it's very easy to put your thumb on the scales and sort of bend over backwards to interpret the law or interpret the facts the way you want to interpret them so that you can get the desired result. It's easy for a judge to let their bias creep into their decision, and that's what I think has been happening. We're hopeful that the Supreme Court's going to jettison the entire tiers of scrutiny and go with originalism, and that's the kind of the inclination of most of those new judges that are on that court. They get rid of this. And I remember when Heller was being argued, Justice Roberts and Justice Scalia were up there on the bench chuckling about how these tiers of scrutiny could be manipulated to get any result you wanted, and they called it like a Rube Goldberg mousetrap thing, where things were stuck on over the years to change this and change that. And what is probably going to happen is they're now going to just look at text, history, and tradition. In other words, they're going to look at what people thought the law meant when they passed it and what they've interpreted it to mean in the years since then, and what kind of laws they've tolerated since then, and see if the modern laws would have been tolerated initially. And in most cases, the answer to that is no, they would not. Certainly in the case of being able to carry a firearm with a license in public. So that new standard of review is going to cause a hard reset, a complete do-over on all the cases that have applied the wrong standard of review, that applied those tiers and then manipulated the tiers to get the result that the court wanted. So we'll be refiling some of the cases that we lost on. We've got a whole slew of new cases that we're going to file, and we still have a number of cases, including a ban on semi-automatic rifles, that so-called assault weapon ban, the ammunition background check requirement law. We've got a case already in the Ninth Circuit on that. We've got a case requiring LA County to issue permits to carry a firearm in public without some kind of special need. In other words, a broad or good cause. And we've got one challenging the ban on magazines that can hold over 10 rounds. That's actually in the Supreme Court right now. So we expect that when the Bruen decision, the New York State case, comes down, all of those cases are going to get looked at again and will likely prevail on most of them or all of them.
So I think that's definitely something that we are going to come back to and probably have multiple videos on in the future, just as far as what these different levels of scrutiny are, how they've been applied to specific CRPA and pro Second Amendment lawsuits in California, and how those needs to get redone. I want to circle back on something you said, though, and kind of rounding out Heller. That decision left some gray areas, and that allows people to interpret the law differently when applying it to other lawsuits. Is the expectation here that the Bruen case ends up filling in the gaps of those gray areas? Because we have federal courts that have completely differing opinions on similar suits. Are we expecting that the decision we get from this case really clear up those gray areas?
Well, yeah, you're talking about, there are different circuits that have ruled that requiring a special need to get a license to carry a gun in public is constitutional, and some that have ruled that it isn't. DC said, for example, that you can't require that kind of a special need. New Jersey said you can. So there's a split. of opinion among the federal circuit courts of appeal about whether or not a special need requirement to get a license to carry a firearm in public is constitutional. That split of opinion is going to be resolved, I expect, by the Supreme Court in the Bruen case, and those decisions that held that you could require a special need will be overturned, overruled, and struck down by the Supreme Court. Now, gray areas is sort of a different question. There are certain laws that we're not sure if they're constitutionality. They haven't been tested yet. So we don't know if they pass constitutional muster yet. Though that's where the gray areas come in. And that's, again, primarily tied back to the standard of review, the test for determining whether or not a gun law is constitutional or not. That's what's been sort of gray, because that standard of review has not been specifically articulated enough, even though it was kind of articulated in the Heller decision, to make lower courts follow it. Once they do have to follow a specific standard of review, they're going to have a lot less ability to play games with the reasoning, although it's not going to be over. The Bruen decision is not the end of the debate, unfortunately. It's maybe the beginning of the end, or the end of the beginning, but it's not the end. We'll still have to file numerous lawsuits. There will still be arguments on both sides about whether any given law is constitutional or not. And that's what CRPA has been doing. We were doing it before Heller came down. We were pushing Second Amendment cases that the Supreme Court didn't take before Heller came down, trying to get this process started and then trying to get all these issues resolved. That's what we've been doing ever since Heller came, for the decade and over a decade since Heller came down, to get these issues resolved and take back California gun owners' rights, because we've been subject to some fairly draconian and pointless and useless gun control laws for a long time. And there's a lot of people who violated those laws accidentally because they're so complicated. I mean, I have a book on this that's 600 pages long that explaining California gun laws. That's not something that really ought to be required of an individual. You know, corporations have compliance lawyers that help them with taxes and environmental laws and all these complicated regulatory schemes. Well, gun laws are as complicated as those, but gun owners don't have, you know, a lawyer standing by to answer questions about gun laws. That's where CRPA tries to help, and our law firm tries to help, and that book tries to help. So getting rid of some of those laws that have taken away our rights and turned some people into accidental criminals is going to be a big step in the right direction as far as CRPA and I are concerned.